Fiduciary duties in corporate law come from the law of agency, and they pertain to how directors need to reflect the interest of shareholders. Remember that directors don't own a company, they only manage it. They're caretakers, they're overseers. The shareholders are the ones that own it. And fiduciary duties really begin with agency duties because there are many times someone is a steward, an agent for somebody else. And so we begin with our study of corporate agency with an investigation into the law of agency. And for those who are interested in going further, the third restatement of agency has many of these points in it. There are two main topics that are important for corporate directors, and those are corporate authority, because in order for someone to be an agent, in fact, they need to have a grant of authority, or at least the appearance of authority that's reasonable. And then once a person has authority as an agent, that creates duties in the agent to do certain things. We have a couple synonyms for principals and agents. Principals might also be known as capitalists, investors, and in fact are the owners. And in the case of corporations, we should add shareholders. Shareholders are the principal, and the agent will be the employee, the officer, the director, the person who is actually running the show. Now, in general, when you have an employee, when you have someone who is your agent, there are two ways that you can make sure that agent is really working for you and not enriching themselves. And they're both expensive. They both have costs, and these are where agency cost comes from. On the one hand, you can monitor them, but then you have to have someone watching the camera to make sure no one's dipping into the till. You have to have someone watching the camera. And then you have to have someone watching the guy watching the camera. Then you have to have someone watching the guy who's watching the guy who's watching the camera. My corporation's professor, Todd Henderson, called this the bee watcher problem, and I invoke Dr. Seuss to help you see how eventually it gets very expensive to monitor. You have to trust your agents to a certain extent. And when you find that they're in fact violating or potentially shirking on the job, you're going to fire them, right? You have to discipline them somehow. Fire them, dock their pay, not award them a bonus. And this is also expensive because when you fire an employee, you have to train the next one. And you have to onboard someone. And as I mentioned, firing an employee can result in liability, employment law liability, right? It can be, and especially if that person has a contract, you may not be able to fire them, but for cause. There also could be union employees that are generally not terminable except for cause, may not be terminable if they're senior, etc. So we have these agency costs, but agency law is designed to help minimize these costs with a set of default rules that have been established under common law and are codified in a lot of corporate law, although the common law of agency really runs through corporate law in a big way here. So how do we actually make someone an agent? We have to grant them authority, and there are several ways a person can receive authority. Authority is required for an agent to bind a principal, and duties arise out of having that authority and acting under it. So all of the authority that we'll find requires some sort of action by the principal. It doesn't happen by accident. The question is going to be to whom that manifestation is made. In the category of actual authority, we have a manifestation from the principal to the agent. Right? So a kind of a first-person manifestation. And so that can either be express. The example I gave when I first talked about this is, Courtney, please go to the store and buy a egg salad sandwich on my credit. Right? And now you're authorized to take that express action. Now, if it so happens that I ask Courtney to do that on a regular basis, there are two things that might arise. One is that on a week which I did not make that specific instruction, Courtney might very reasonably believe that she is authorized to purchase that egg salad sandwich from the corner store, and that's called implied authority. Implied authority is when manifestations made previously or a manifestation made now that is not covering something very specific within its scope. Right? Maybe I didn't authorize her to also grab napkins, right? But some things are implied with purchase of an egg salad sandwich. It's messy, you need some napkins, so there's some things that are implied as well. Where do we find express authority in corporations? Usually we would try to look for them in a writing. That's going to be our best source. We're going to document that in our corporate minutes at a meeting. We could have a written consent of the directors who are the situs of authority in a company. The shareholders appoint the directors, and then they have the authority to run that company. It could also be in the bylaws and potentially in the charter, depending on what type of authority that is. But actual authority is going to be when the principal makes a manifestation to the agent that creates a reasonable belief within the agent of that authority. And so express authority will be written or directly communicated. Implied is going to be inferred from the facts and circumstances. And the third restatement of agency, section 2.01, says that an agent acts with actual authority when, at the time of taking action, that has legal consequence for the principal, the agent reasonably believes that in accordance with the principal's manifestations to the agent, the principal wants the agent to so act. Now, we also are going to have apparent authority. And so that shopkeeper at the corner store who remembers Courtney coming by every week and asks for that egg salad sandwich to put on Professor Orenberg's tab, and I'm paying the bill. Right now, that storekeeper also has a belief. That storekeeper would have a belief that Courtney is my agent, and that's because I am paying the bill. When Courtney goes in and buys that egg salad sandwich, I didn't refuse to pay. I'm routinely making those payments. And there are other ways in which apparent authority can be manifest, but the difference here is now the principal is making a manifestation to a third party. I may or may not have told Courtney anything, but that's not part of the analysis in apparent authority. It's what someone else witnesses or experiences. And the third restatement of agency, section 2.03, says that apparent authority is the power held by an agent or other actor to affect a principal's legal relations with third parties when a third party reasonably believes that actor had authority to act on behalf of the principal, and that belief is traceable to the principal's manifestation. So again, we need a manifestation by the principal, but the distinction between actual authority and apparent authority is that in actual authority, the manifestation is to the agent. In apparent authority, the manifestation is to the third party. Now, maybe that manifestation was not made and an action was taken, but later on, I want to approve it, right? So I did not tell Courtney to buy me an egg salad sandwich, and the shopkeeper had never heard of me before. But for whatever reason, Courtney gets the sandwich, the shopkeeper puts it on a tab with my name on it, and I later go down to the store and I pay that tab. I've just ratified that prior action, which effectively relates back to the prior act and authorizes it. It sort of works a little time warp. Right, so even though I'm authorizing it by ratifying it now, that authority relates back to when the action was taken. And the restatement says that ratification is the affirmance of a prior act done by another, whereby the act is given effect as if done by an agent acting with actual authority. And the important thing, again, to remember about ratification, it still requires a manifestation. As I said, all authority requires a manifestation by the principal. It's about that manifestation happening after the act, not before it, but it has this time warp feature of creating the authority retroactively, as when the act occurred. And finally, sometimes we can also have an equitable doctrine which creates authority, which would be estoppel by silence. And so if I simply don't say anything while Courtney is buying me a bunch of egg salad sandwiches, I'm aware of it, a court might say it's unequitable for me to refuse that authority grant, even though I may never have ratified it. So that is one way where it isn't a grant of authority through a manifestation, but I'm sort of, if you will, making an inverted manifestation by my omission, by my silence. And that is, again, an equitable principle, not a legal principle. So maybe a more specific way of saying it is that authority, when granted by law, always requires a manifestation, but sometimes an equitable doctrine will fill the gaps. It's not quite the same thing as actual granting authority, but it has a similar effect because the party is then stopped from denying that authority. So it was never granted, but I can't deny it in law. So now we have granted our authority to our agent, and now the agent owes duties to the principal. So what do those duties look like? Again, we're in basic agency law here, but I think you'll see a lot of parallels between the law of agency and agency law and the law of agency as it relates directly to directors. So we have quite a number of duties that are created in agency law, and these numbers that you see here are references to the third restatement of agency. And in fact, some of these are directly parallel. There is a general fiduciary principle, right, that states very broadly, 8.01, an agent has a fiduciary duty to act loyally for the principal's benefit in all matters connected with the agency relationship. Now we're going to get a little more specific, and we're going to divide it in our restatement of agency world between duties of loyalty and duties of performance. But I hope you can see a strong parallel between this and the duties of loyalty and the duties of care, right? And think about where the duty of oversight fits in to these duties. There are some very strong connections. So an agent has a duty not to acquire a material benefit from a third party in connection with transactions conducted or other actions taken on behalf of the principal or otherwise through the agent's use of the agent's position. And this sounds a lot like the corporate opportunity doctrine, which says that a director cannot usurp a corporate opportunity. It says a little more specifically, and this is that underlying principle behind that corporate law. An agent has a duty not to deal with a principal adversely in connected with an agency relationship. So this is an issue when someone stands on both sides of a transaction, right? If you are both financing a company and sitting on its board, what price is that financing going to be for? Right? We have an issue here. We have a duty not to deal in that manner. Of course, corporate law has a couple twists and turns that help us resolve those issues. Throughout the duration of an agency relationship, an agent has a duty to refrain from competing with the principal and taking action on behalf or otherwise assisting the principal's competitors. And so a director would have a very hard time sitting on the board of both Microsoft and Apple, right? That would be acting on behalf of a competitor. There is also a duty not to use the principal's information for an agent's own purposes, sort of usurping its shareholder lists, its customer lists, which can be very valuable. And finally, we have kind of a concept of ratification, which is going to our concept of cleansing a director conflict of interest transaction, a DCIT. Conduct by an agent that would otherwise constitute a breach does not constitute a breach if the principal consents. And those are our general duties of loyalty. On the other hand, we have our duties of performance, or you might say duties of care, if you want to put it in corporate language. And we begin with section 8.08, really, right? The 8.07 is a little general. Duty of 8.08, duty of care, competence, and diligence, right? Right there, duty of care, which reads, subject to any agreement with the principal, an agent has a duty to the principal to act with care, competence, and diligence normally exercised by agents in similar circumstances. And so once again here we see a very strong and important parallel. The duty of care to which directors are held is not how that one director is acting. We're going to see in Francis v. United Jersey Bank, there was a woman who was on the board who had no financial knowledge. She's not going to be held to the standard of a person with no financial knowledge. She's going to be held to the standard of a director in a like position. And that's similar to 8.08 from our agency law. And so those are sort of our key duties here. As I mentioned, we have really shrunk the duty of care, and we're going to not find directors liable unless they have not acted with competence, diligence, what I'll call paper and process. Directors really have three then major duties, and those duties as I see them, some will group oversight into either care or loyalty, but for reasons I think will become evident, I set that aside. We have a duty of care, which has to do with commissions, with actions taken. When you take an action, you have to do it with paper and process. There's a duty of oversight, which has to do with omissions, the failure to monitor, an utter failure to monitor. And the duty of loyalty, which is when a director stands on both sides of a transaction or takes a corporate opportunity. Now, we want directors to be protected from care breaches because so long as they're acting with paper and process, they're doing their job. Right? They're trying to make decisions on behalf of the corporation, and the shareholders benefit when the directors are able to take those risks. On the other hand, breaches of loyalty when when a director is stealing from a company has no social benefit, and so courts are going to be more inclined to find liability in those cases. So let's start by addressing the duty of care, and the duty of care has three major topics in it, or we'll talk about three major things here. We'll talk about the traditional duty of care, the evolution as found in the Van Gorkom case, and the way the business judgment rule interoperates with the duty of care. And also we'll then touch on how to eliminate the duty of care. So we'll start with the case of Schlensky versus Wrigley, kind of a fun classic case where a director was not found liable. We'll move to Van Gorkom, the case that shook the corporate world when a board of directors was found liable even when they made a decision. And then we'll talk again about the business judgment rule, how it protects directors, and how Delaware enacted Section 102b7 to create a stronger business judgment rule when corporations so elect. Schlensky versus Wrigley was about nighttime baseball, and the Cubs play at Wrigley Field, right? And Mr. Wrigley was still alive and well at the time, and he was running this company. In 1968, however, the Cubs were the only Major League Baseball team that did not play night baseball because they did not want to install lights. They didn't want to install lights because Wrigley said, one, baseball is, in his words, a daytime sport. That's the nature of the game, and it would hurt property values in Wrigleyville if he installed those lights. Now, what's interesting about those on their face is they don't sound like they're really to benefit the shareholders. One is his personal whimsy, that this is a daytime sport, and the other is trying to engage in some kind of corporate social responsibility by maintaining property values in the neighborhood. However, the court dismissed the claim against Wrigley, dismissed Schlensky's suit. Schlensky, again, was a shareholder, said he did not have a claim because in order to have a claim of a breach of the duty of care, when a director has made an affirmative decision about the business and how the business operates, Schlensky would have to allege that there was fraud, illegal conduct, or a conflict of interest. Otherwise, we're just not going to allow these claims to proceed, even though here there didn't seem to be a good business reason for doing it. We actually gave a massive presumption to the director saying, okay, if you say night baseball is good for the Cubs, we're going to take you at your word. Now, this should be contrasted with the case of Dodge v. Ford, the classic case where Dodge said he's going to sell the cars, Ford cars, for less than they're worth because he wanted more people to have cars and his shareholders were too rich. He wanted them to have less money. He actually went on record saying he's trying to hurt the shareholders who he didn't like and who included his competitors, the Dodge brothers. That was a different case because he really went out there and said things you really shouldn't say, that you want to screw over your shareholders, not a good idea if you want to win the case. Here, Wrigley didn't make any of those kind of allegations. He simply said that the Cubs are better off playing daytime baseball, and the court said they're not going to speculate on the validity of this business judgment. They said, and I quote, "It appears to us the effect in the surrounding neighborhood might well be considered directors who are considering what patrons would or would not attend the games." Right? If in fact the lights were put up and that drove down property values, maybe people wouldn't want to go to this downtown arena in 1968. They're not going to speculate on whether or not. That at least makes enough sense that we're going to allow that decision to stand. The long-run interest of the corporation and its property value at Wrigley Field might demand all efforts to keep the neighborhood from deteriorating. Again, the court is almost saying, we're not going to speculate, but we'll speculate that there could be some good reasons here. And as we'll see, this is called a rational basis review. We're just looking to see, was there any reason, not even a good reason, but any reason for this decision? And the court reminds us what was missing from the complaint. What did Schlensky forget to say? There was no allegation there would be a benefit to the corporation from night baseball. Right? It could increase the cost. You got to install the lights, run the lights. And no mention was made of the operation of maintenance of the lights. We cannot speculate as to what other factors might influence the increase or decrease of profits. Now, we know how this case ended. Wrigley died. On his deathbed, he told his son, "Never sell my Cubbies." And what did the son do? He sold the Cubs to the Tribune, and the Tribune then installed night baseball games. And eventually, in 2016, the Cubs won the World Series. World Series aside, what does the case teach us? That we're going to have in the traditional approach to the business judgment rule a rational basis review. And this is a very low, this is a very hard burden for the shareholders, high amount of protection for the directors. Schlensky held that directors' decisions will not be questioned so long as they have some rational basis. Now that seemed to change in Smith v. Van Gorkom, which added a requirement that in order to have the protection of the business judgment rule, we need to have paper in process. It doesn't count as care if you weren't careful. And there was also some undertones of conflict of interest here, duty of loyalty type issues, because Van Gorkom might have been in a different position than the rest of his shareholders. So what was going on with TransUnion? TransUnion was a large company. It is now in financial services, but at the time it had been in the business of owning and leasing rail cars. And rail cars are an asset. Assets depreciate over time. It's a financial concept, meaning that you take losses based on assets that you have that may not be reflected in the actual value of your property going down, but we take those losses, and for that and other reasons, TransUnion had a lot of losses on its accounting books. And they weren't making enough revenue to cover those losses, so if they simply kept their main course of business, they're going to lose these tax credits, and so there was all this money that they were potentially leaving on the table. And there were some ways to deal with that. Well, I mean, you could go to Congress and lobby for them to buy back your tax credits. You could acquire a business that generated more income, right? So use some of your cash to buy a business. Or you could sell yourself to a company that wants these tax credits, because the tax credits would come with the company if the transaction was done in the right way. And so the CEO at the time, Jerome Van Gorkom, he was the CEO of the board, and and chairman of the board. And what did he do? He decided to get into conversations privately, secretly, with a man named J. Robert Pritzker, who was a billionaire private equity money manager. And through these conversations, Van Gorkom, without really telling anyone on the board what was going on, agreed on a $55 per share price, which was a 50% premium over what the company was trading at the time. And they actually went ahead and had a board meeting after this was kind of settled, and over a 2-hour meeting, the board decided to sell the company. Now, that's actually pretty quick, and there are some things that didn't happen at this board meeting that we'll later learn should have happened. The board didn't read the merger agreement. There can be a lot of terms in there. And the board took Van Gorkom's word that the company was getting a good deal at $55 a share. Right, so the board is making a decision, but here that decision's not informed because they were missing a key piece of information. They didn't know what the corporation was really worth. And so you can't be protected by the business judgment rule unless you're making a business judgment. And you're not making a business judgment if you're not informed. And knowing the value of what you're selling is critical to being informed. And so the board here didn't meet that standard. Now, they tried to solve this by having a process called a market test, which meant that they were going to shop the company for 90 days after the transaction was announced. They only had 2 potential bidders. Neither was able to do the deal in that time frame, and the court held that that was not enough to cure the problem. They also put this to a shareholder vote. The shareholders' opportunity to approve and ratify this transaction. And we're going to talk about that process, especially with director conflict of interest transactions and cleansing. You might think, well, if the shareholders approve it, it must be fair. But again, the shareholders were not informed. They did not know the share price. The directors did not meet their duty of informing the shareholders. And so Van Gorkom really rocked the corporate world because the shareholders won. Right? There was no business judgment rule presumption, and the business judgment rule presumption would have essentially been an insurmountable barrier that the shareholders could not have crossed. Delaware General Corporation Law, Section 251, ensconces this, saying, under Delaware law, a director has a duty to act in an informed manner in determining whether to approve an agreement of merger before submitting the proposal to shareholders. And that before language is critical. The market test that happened afterwards was of no moment. Now, the board tried to defend. They said that they secured an offer that was 50% higher. Okay, fine, 50% higher, 20% higher, 100% higher than the market price, but we don't know the real price of this value to Jay Pritzker or to somebody else. That wasn't actually done. 50% might sound nice, but we have no way to measure that metric. They had a market test, but that was after the fact, and only a few firms showed interest, and they were kind of scared away by the quick deadline. This happened, by the way, even though the directors were very knowledgeable. Right? It doesn't matter how smart they were. They just didn't put the time and effort into it that they needed to. And so there have been some outcomes from this, right? And the directors then were found to then breach, again, because they failed to inform themselves, one, and they failed to disclose to shareholders. And that had 2 problems. The failure to inform themselves breached their duty of care because they did not go through the paper and process necessary to become informed about this transaction. And they did not inform the shareholders, so the shareholder ratification was voidable or ineffective because the shareholders also were making a decision without information, but it is not their duty to inform themselves. As we see from DGCL 251, the directors have this duty to inform the shareholders. So what did practitioners do in response? Well, they make the meetings longer. Right? How long? Well, I don't know, maybe you have 2 days to look at a merger agreement. One thing that has become more prevalent is having the directors initial the pages of the merger agreement to make sure that they've actually seen every page. But presenting directors with a stack of 700 pages and telling them, please read this, may not be effective either. So some have questioned the utility of the response to Van Gorkom. This case has not reared its ugly head again, but the corporate world was really spooked by it, and so they have really tried to institute more procedural safeguards to prevent this from happening. Some good tips. What should directors do in order to avoid being held liable for breach of the duty of care after Van Gorkom? Directors should review written materials provided before, at, or during the meeting. You may also want to have a presentation summarizing those materials to make sure the directors have actually understood what they were presented. They should be paying attention in the deliberations. They should be actively participating. They should consider information generated by persons other than those retained by the corporation. We might want to look at some third parties that are going to give some reliable information about the value of this transaction. And they may want to communicate again with outsiders who are going to give unbiased information. And so Van Gorkom really changed the way people practice corporate governance, and I think that is important because clearly some things were going wrong, although I'm not sure that signing every page of a merger agreement is the solution. There are some other solutions if you want to avoid director liability. You can avoid it in several ways that are permissible under Delaware law. The first is staying within the business judgment rule. The business judgment rule is a presumption that protects directors when they make an informed decision that is a business decision. Exculpation is under Section Delaware DGCL 102B7, and that permits a corporation to not allow shareholders to sue the directors for duty of care breaches. We can provide indemnification where the corporation will step into the shoes of a director who's being assailed by a suit, and we can also insure them by purchasing D&O insurance, although that can be expensive. So what is the business judgment rule? The business judgment rule is best understood as a rebuttable presumption, but a very strong presumption, hard to rebut. And what do we presume under the business judgment rule? We presume under the business judgment rule that when a director has acted with paper and process in making a business decision, that they're acting honestly, that they're well-meaning, that they're informed and rational. Shareholders have to show that the director was not acting honestly. Shareholders have to show affirmatively that the director was not well-meaning toward the corporation, or that the directors were not informed, or the directors were acting totally irrationally, that there's no rational basis. In other words, the business judgment rule protects directors from their decisions that are made in good faith. And that is most decisions, and Van Gorkom was the outlier. They found that there was a lack of good faith because Jerome Van Gorkom, who was 62 and retiring, seemed to have this interest that was deviant from that of his shareholders, and the board, who was his friends, kind of seemed to at least push the merger through without really considering the value of the company and could have cheated the shareholders out of quite a bit of their stock value. We can also help strengthen the business judgment rule through exculpation. And exculpation is a provision that you put in your charter, and by the way, when you revise a charter, you need to have the approval of the shareholders. So the shareholders have to approve this, and when they do, we can look at public companies and see if the value of the company goes up or down. That's been an empirical study that's been done. It's been inconclusive. But it effectively eliminates, or at least seriously reduces, the personal liability of directors for money damages, but it doesn't prevent liability for everything. Exculpation clauses do not cover breaches of the duty of loyalty because duty of loyalty breaches are not something the shareholders want to protect directors from. There's no social value from the directors or the agents stealing from the shareholders or the principal. It doesn't cover bad faith, and so a shareholder can still show bad faith decisions and get recovery for that even if there's an exculpation clause. It cannot cover intentional misconduct where the company is, or waste where they're throwing away the money. Unlawful issuance of dividends is never protected, and any transaction where the director themselves received improper benefits. Often when you find a director conflict of interest transaction, or invoking again the corporate opportunity doctrine, which is a subset of the duty of loyalty. So there's a little bit of redundancy in there as we try to capture all those concepts. But it would have probably protected Van Gorkom. Exculpation would have protected the board who made a quick decision. Right? That was still a decision. Right? It was not in bad faith. There was nothing intentionally illegal about it. It wasn't about the issuance of dividends. The other directors had nothing to gain from it, so it was no personal gain from it, so it was no issue of loyalty. So if we had, and again, this 102b7 provision in the Delaware General Corporate Law was enacted after Van Gorkom as a response to it. And most would agree that Van Gorkom would have come out differently, and that we would not have found liability for the directors if they had an exculpation clause, because under those facts, we don't hit on any of these things that cannot be exculpated. We can also indemnify the corporation, which means stepping into its shoes of the directors who suffer a loss. And this can either happen during the suit or otherwise. So we have a couple provisions that we should look at. Indemnification is authorized both under class actions, that's subsection A, and under derivative suits, which are a special way of suing the corporation, requiring the corporation to sue itself, that has a demand requirement. We can provide costs to the directors when they prevail on the merits, and we can actually provide the funds in advance, although that's somewhat contentious. And there can be other rights that are permitted as well. And so under indemnification, this can be pretty broad, and now the corporation is now going to protect the directors in an additional way by saying, fine, even if we don't dismiss the case because the business judgment rule applies, we'll step into your shoes, we'll pay your legal expenses, and we'll reimburse you for costs if you're successful. If they elect to do so, this is an optional thing. Corporations do not have to provide indemnification, but DGCL section 145 authorizes the indemnification of directors by corporations, and it also authorizes the issuance of insurance. This is also in section 145 subsection G. Insurance works just like insurance in your usual life. Something bad happens, the insurance company steps in and pays for it, right? So you pay a premium, right? If you have health insurance, you pay a premium every month. If you get sick, then the insurance company will pay some amount of your medical bills. Now that number may not be 100%, and rarely is 100% with D&O insurance as well. In fact, in the Van Gorkom case, there was insurance. It didn't cover the whole thing. So the settlement would have gone over and beyond that insurance amount. Just like your insurance may not cover all the claims you have on your car or on your health insurance, but you decide what insurance you want to buy. You decide what plan you want to pay for. Now D&O insurance can be very expensive because there is a lot of liability out there. But when it's effective, it reimburses the company for its lawful expenses in connection with indemnification. So now the company is not just paying itself to sue itself, but it can actually get that money from a third party. It covers claims against individual directors or officers when they're acting in their corporate capacity. It then reduces exposure to the corporation, and it goes beyond indemnification because it can cover more things. And again, with indemnification, the company, if there's a derivative suit, that means a shareholder is asking the company to sue the directors. And if there's indemnification and the directors, the corporation's in the shoes of the directors, that derivative suit means effectively the corporation is taking money out of its own pockets. Insurance can solve that problem to an extent. And it's authorized by section DGCL 145G. So that's the duty of care. Next, let's look at the duty of oversight. And as I mentioned at the start of this talk, some will group the duty of oversight into the director function of care, and others will group the duty of oversight into the duty of loyalty. That seems to have shifted over time as it has become harder and harder to show and prevail on care claims, especially with corporations that have an exculpation clause. As mentioned in the previous slides, if a corporation has an exculpation clause plus indemnification, it's going to be very, very hard for the shareholders to get any recovery, maybe not even to prevail through the motion to dismiss phase. Directors, again, have a couple functions. They have to make decisions, and those decisions are, I'll call commissions, and those decisions have to be made with paper and process. Otherwise, the Van Gorkom effect kicks in, although you can exculpate away from that. When they make decisions, they're generally protected by the business judgment rule. So long as they're well-intentioned, they're not in bad faith. Then we have the obligation to not take a corporate opportunity when making decisions. So an opportunity comes along and you don't take it for yourself. That's the duty of loyalty, which we'll cover next. The duty of oversight seems to fit somewhere in between because it has to do with omissions. It has to do with when a board does not do something, fails to implement some type of oversight, and does not prevent a harm from occurring. So when is a director going to be liable for not preventing a harm? Well, let's see a case where we have classic oversight failure, right? This is the case that stood for the rule that a director cannot protect yourself behind a paper shield bearing the motto, dummy director. And the image here, a little tongue-in-cheek, but as you might remember from the case here, we have Pritchard and Baird, which is a reinsurance company, and Ms. Pritchard, right, as named in it, was the wife of Charles Sr. Charles Sr., when he ran the company, ran it as if it were his own personal piggy bank, and his two children, also shareholders, continued that after Charles Sr. passed away. But after Charles Sr. passed away, Ms. Pritchard, who had not taken any interest in the company previously, took even less interest and became grief-stricken, became an alcoholic, and literally stayed in bed all day, did not attend meetings, did not review the books and records, did not perform any oversight. Now, what would she have seen if she had actually performed those oversight duties? She would have seen that her sons were misappropriating funds. They were doing this through issuing shareholder loans to themselves, and they were using money that they were fiduciaries of. As a reinsurance company, they had they were an agent of some principals, and so they were supposed to segregate funds, operating funds, from insurance companies that it was supposed to pass on. They were A, not segregating those funds, and B, issuing it to themselves in the form of shareholder loans that weren't being paid back. So Ms. Pritchard dies, and her executrix is sued, right? And so what result? Is the executrix and therefore Pritchard going to be liable? Yes, the executrix lost this case because Ms. Pritchard never made any efforts to discharge her duties. If she had, she would have realized her sons were misappropriating funds. So what do we learn from our first case in the duty of oversight? What does a director have to do at a minimum? Has to be familiar with the business fundamentals, has to understand the nature of the business. You don't have to be an accountant to deal with an accounting firm. You don't have to be a biomechanical engineer to be a director of a biomechanical engineering company, but you have to be familiar with the business fundamentals, and you will be judged not based on what you actually know, but what a reasonable director in similar circumstances should know. What else? You need to be informed, right? She failed to do that. She wasn't getting out of bed in the morning. She wasn't paying any attention to the stealing at the till. Provide some general monitoring. At this point, we have this concept there should at least be some oversight, and attending board meetings and then objecting to problems. If a person finds problems and does not object to them. So what was she doing? Was she familiar with business fundamentals? No, she was drunk, not paying attention, asleep at the switch, lying in bed. Was she informed about corporate activities? No, she was completely incompetent. She made no efforts to make herself informed whatsoever. Was she doing general monitoring? No, she was totally lackadaisical. If she had even glanced at a single accounting statement, it would have been dead obvious that her children were stealing from the company. Did she attempt to discipline them in any way? No, she made no efforts whatsoever to engage in her activities. And so under these circumstances, these unjustifiable non-efforts will not give her deference under the business judgment rule. This case was tried as a duty of care claim. It succeeded because she did not meet even the most minimal standards. So what should a director do? Practice pointers. Attend meetings. Directors, you only have 4 meetings a year. You should go. You should stay informed about the company. At those meetings, you should set corporate policy and corporate strategy. One of those things is to hire, fire, and decide how much to pay executives. As we'll see in a case about the corporate opportunity doctrine, also decide how much to pay yourselves. That's a conflict. You have to monitor the business for illegality or misconduct at least, and inquire and object with necessary. Now, later a case came that was overruled. This is no longer good law, but Graham v. Alice Chalmers held for the proposition that directors only need to respond to red flags. They have to attend meetings, they can't be asleep at the switch, they can't be dead incompetent, but they don't have a bigger obligation than that. They simply have to respond to red flags. And the key term here was that the company did not need to establish a corporate system of espionage, did not have to ferret out wrongdoing. I mention this in passing because this is not the law. This has been overruled by Caremark. So put a red flag on this one. If you have it on Westlaw, it has a big red flag on it because this is no longer good law. The concept is not that you do not have to ferret out wrongdoing. In fact, there is an obligation of directors to do exactly that, to ferret out wrongdoing. And how does one ferret out wrongdoing? Let's not use the pejorative term corporate system of espionage, right? But how do you actually do this? You need to institute monitoring systems. That's the lesson from Inri Caremark International derivative litigation. That directors could be liable. They were not actually found liable. This had to do with procedural posture, but they could have been found liable such that a case would not be dismissed where directors failed to do any appropriate oversight. So this stands for this is the modern version. This is oversight of the modern corporation. We're going to add on top of this some rules that came out of Sarbanes-Oxley. And it stands for the notion that directors can be liable for oversight failure, which includes or amounts to a lack of supervision, that you're supposed to make sure the employees are not committing illegal activities, are not stealing from the company, are not engaging in misconduct. And directors can be penalized for improper inaction. Right, so now omissions as well as commissions can create liability. So what do you need to supervise for? Well, we'll talk about both legal risk and business risk. You definitely need to supervise for legal risk. And that's what happened in this case. In this case, there was multiple felonies that were occurring at Caremark. On the other hand, monitoring for business risk, because there's going to be liability for that. We're going to see that when we come to the Citigroup case. And in Citigroup, the company failed to sell its collateralized debt obligations before a market crash. That turned out to have a different result. So keep that in mind as we turn to the cases. So we know that directors can be liable for several things. They can be liable for self-dealing, right? That's the duty of loyalty. They can be liable for an ill-advised or a negligent, now we're going to add negligent to Van Gorkom, right? That's the duty of care, although we can exculpate a lot of that away. Or, as we see in Caremark, a liability for an unconsidered failure to act that results in a harm to the corporation. And so what did that look like? Well, in the case of Caremark, this was again a breach of the duty of care case. And the Caremark employees, despite their name Caremark, were not exactly taking care with the law. They were charged with multiple felonies for offering kickbacks to physicians for prescribing certain medications. By the way, kickbacks are illegal, so this was clearly illegal conduct. It was widespread. It was so widespread that the Department of Justice and the U.S. Department of Health investigated them, charged them with multiple felonies. They pled guilty, right? They didn't settle. They pled guilty to mail fraud, and the criminal and civil fines exceeded $250 million. So the plaintiffs advanced a theory which is very difficult to prove. They claim that a director allowed a situation to develop which exposed the corporation to enormous liability, and that resulted in a duty of care breach. Interesting, they couch this in the claim of duty of care, not duty of loyalty. That would lead me to think that this company did not have an exculpation clause in its certificate of incorporation at the time of this suit. Now, the court found that although there was a low probability of a care claim proceeding, it was not zero. It was not zero, and so now we see that there are maybe some additional liabilities that come out of the Caremark case. Liabilities for failure to monitor. Liabilities for failure to ferret out wrongdoing. Especially where it leads to these large financial losses, right? We have to get to the harm, right? We need to result in loss to the corporation. So what do we learn from these cases? Well, we learned that directors are allowed to be stupid, right? We appointed them, right? We knew they were stupid when we picked them, and it's our fault, shareholders, for picking the dumb guy to run the company. We can't hold that against him, right? But on the other hand, they're not allowed to be lazy. They're not allowed to take no action. They're not allowed to fail to become informed, to fail to discharge their duties. And one of those duties then is going to be to attempt in good faith to assure that a monitoring system exists that will, in fact, raise red flags, right, when there is wrongdoing. So some kind of system that's going to prevent kickbacks, maybe some training, like other major laws that companies should worry about. Foreign Corrupt Practices Act. If you do business in certain foreign countries, you may be asked to bribe an official, right? That's illegal under the Foreign Corrupt Practices Act. That's a corrupt practice, right? It's illegal in America. There can be a lot of liability for that, treble damages. So companies have to have some kind of program. It doesn't have to be perfect, as we'll see in our next case. It doesn't have to always work, but it has to at least exist. And at least in some circumstances, failure to have one of these programs could render a director liable. And so now we have additional duties under the duty of care. Although, as we'll see when we have more exculpation clauses, maybe we can characterize these as loyalty claims. So, what do shareholders have to prove? What are the elements of a Caremark claim? There are 4 elements in a Caremark claim. One, that the directors knew or should have known that violations were occurring. And the should have known is really important. It's important enough that I separate that to a separate element. I often will write KOSHK, known or should have known. But here, the should have known is really important because that's what's different about Caremark here. That's that duty to ferret out wrongdoing. That's that obligation to have monitoring systems. Right now they're liable for things they should have known about if they had had functioning monitoring systems. Then the directors took no steps in good faith to prevent or remedy that situation, which can happen if they're not aware of it, and this proximately results in losses. We still need to get to harm. We also, by the way, will have some additional controls required by Sarbanes-Oxley Act of 2002, and that's going to require some additional disclosures from certain types of companies, especially financial companies. And we're going to have to provide some audits and have some internal, external controls that are required in part of our general risk management. One of that from SOX, Sarbanes-Oxley is often abbreviated SOX or SOX, Section 404, talks about management assessment of internal controls. Each annual report of an issuer, a company that's filing publicly, shall have an internal control report which states the responsibility of management for establishing and maintaining adequate internal controls and procedures for financial reporting, and contains an assessment as of the end of the issuer's financial year of the effectiveness of the internal control structure and reporting procedures. And so we have a couple additional obligations on top of Caremark duties that are imposed by statute, namely Sarbanes-Oxley, and the Dodd-Frank Act added a few more as well. What about acting in good faith? So Stone v. Ritter sort of stopped that train. So Caremark expanded the liabilities, and Stone v. Ritter kind of put some limits on when directors will be liable for failure to monitor. So what happened at AmSouth Bank? AmSouth Bank failed to file a suspicious activity report. And so banks, when someone tries to open an account or when uses an account, sometimes they're using that account for illegal activity. They may be using it for money laundering. They may be using it, in this case, for a Ponzi scheme. So there's a Ponzi scheme being perpetrated right out of AmSouth Bank. Lewis Hamrick and Victor Nance perpetrated a Ponzi scheme using a bank account at AmSouth. And had they filed a suspicious activity report, they would have potentially stopped this scheme from defrauding millions of Americans. And we don't have to speculate, right? They actually were found liable, and they paid $40 million in fines, plus $10 million in civil penalties. So they definitely committed some wrongdoing here as a corporation. Then the United States said that AmSouth lacked an adequate compliance program. And the shareholders are saying, oh, lacking an adequate compliance program. We got some Caremark claims here. Maybe we can recoup some of those damages. Now, the directors didn't see red flags, but we're not under Graham v. Alice Chalmers. That's not good law anymore. So they didn't need to see good flags. They needed to put themselves in a position where they would have seen them because they were going to be liable for things they knew or should have known. All right, so what happens here? Well, actually, the shareholders lose. As I mentioned, this puts a limit on the extent of liability. The Stones claim that the directors utterly failed to implement any sort of statutorily required monitoring system, and that just wasn't true. That just wasn't true. The company had instituted some systems. The systems obviously didn't work, right, but they were instituted in good faith. There wasn't an utter failure to monitor. There wasn't a total lack of systems. The directors, in fact, had an independent auditor who said that these systems were good. Right? And so they went through the paper and process, if you want to think of it that way. An important lesson here, just because there was blame, just because there was damage, does not mean there was bad conduct, does not mean bad faith. A bad outcome does not necessarily imply bad faith. Right? So we have a rule from Stone that where directors fail to act in the face of a known duty to act, thereby demonstrating conscious disregard for their duties, they breach their duty of loyalty. Their duty of loyalty. Right? Because we're not going to succeed on a care claim. So we're going to try it under a loyalty claim. They breach their duty of loyalty by failing to discharge that fiduciary duty in good faith. And why is good faith important? Because good faith is what makes us a loyalty claim. When they're acting in bad faith, we're assuming they're acting in their own self-interest. right? That's a loyalty claim. They're doing something else that enriches them instead of monitoring the company. We're going to try to couch this as a loyalty claim because duty of care claims are non-starters, especially if there is an exculpation clause. These directors failed in the act of a known... they did not, but the charge would need to have shown that they failed to act in the face of a known duty to act. Right? That means utterly failing to implement any reporting or information systems or controls. That didn't happen. They had systems and controls. They didn't work well. They had an independent audit. It seemed like they were acting in good faith. They made a business decision to implement those systems. We're not going to let the loyalty claim persist here. Or, having implemented these controls, they just didn't pay any attention to them. Okay, that would be a problem as well, if they implemented them and then stepped away from the dashboard and didn't pay any attention. So, how do we succeed in this Stone v. Ritter world where plaintiff will have to show a failure to act in good faith to show that there is a duty of loyalty violation? And so we're now going to couch the duty of oversight within the duty of loyalty. That's why I separated, right? It could be said as a duty of care, duty of loyalty. Maybe it makes sense as a third duty. Otherwise, if we're going to be in the business judgment rule, if we're going to be in the duty of care world, the exculpation clause would apply. So we need to show that there was a breach of bad faith. And what would constitute a breach of bad faith? Well, the court says to have a breach of bad faith here, a breach of good faith, we need to show an utter failure. Right? We need an utter failure. Only a sustained or systematic failure of the board to exercise oversight, such as an utter failure to attempt to assure reasonable information systems exists, will establish the lack of good faith that is necessary for liability. Again, strong standard to meet to have an utter failure. Was there an utter failure in Citigroup? What happened here? In Citigroup Incorporated shareholder derivative litigation had to do with subprime risk. So for those who remember, 2007, 2008, there was a lot of mortgages sold that were subprime, meaning that they were sold at higher than normal interest rates to people who were generally not qualified to get a loan. And part of the reason that these mortgages were made in the first place is because the people selling the mortgage were able to resell that mortgage to someone who would then repackage it using some complicated math into something called a collateralized debt obligation. And we could talk on and on about tranches and the physicists that program these things, but the concept was effectively that you could take a bunch of garbage and turn it into gold. And it turned out that didn't work so well, right? The financial alchemy didn't pan out. We end up with a market crash. Citigroup held billions of dollars of these CDOs or CDO squareds, which were an even more, they were like CDOs packaged into CDOs and tranches of tranches, and you can't turn garbage into gold, it turns out. And these investments turned out to be garbage, which led to this crisis. And then what happens when there's a crisis? Well, the shareholders sue. They allege that the directors breached their fiduciary duties by failure to monitor the lending market. Now, how is this different than the case we just saw? We just saw two cases, Caremark, Stone. Both of those cases had a legal risk, committing fraud. Right, failing to comply with the suspicious activity results, offering kickbacks, violating the Foreign Corrupt Practices Act. Those are legal risks. But what about the decision to hold an asset? This is a financial company. It's their job to hold assets, and the board's job is to decide which assets to hold. Right? So this is going to be a different. This is a clearly different kind of case because this is a business risk. Right? This is not, in fact, an oversight claim. The shareholders alleged the breach because they ignored red flags, but you know what? They were reading the newspaper. They knew exactly what was going on. They made a business decision to buy and hold these assets. And so demand is not excused. Their business is monitoring financial risk. The directors were engaging in their business, and you don't like the directors, vote them out. Or sell your shares. If you think directors are stupid, making bad decisions, well, you can leave the company. You can vote new ones in next time. So this was a type of liability, attempt to find liability for a failure to monitor. But this just didn't work because this was not the type of monitoring that we're talking about. This was a business decision. It is well established, the court said, that the mere fact that a company takes on business risk and suffers losses, even catastrophic losses, does not evidence misconduct, and without more, is not a basis for personal director liability, that there were signs in the market that reflected worsening conditions and suggested that conditions may deteriorate even further, is not an invitation for this court to disregard the presumption of the business judgment rule and conclude the directors are liable because they did not properly evaluate business risk. What plaintiffs are asking the court to conclude from the presence of these red flags is the directors failed to see the extent of Citigroup's business risk and therefore made a wrong business decision by allowing Citigroup to be exposed to the subprime mortgage crisis. And so again here, we do not have a claim because this is a clear business decision and those are protected by the business judgment rule. Key point for those in the room who are planning on working in corporate law, you also have a duty to report misconduct. You are part of this system. There is an ethical duty. If you see wrongdoing, if you know that kickbacks are happening at your client, you have a duty to report that to your partner. You may have a duty to bring that to the attention of the general counsel. You may have a duty to bring it to the board, right? So consult your legal ethics when that comes up. All right, part number 4, the duty of loyalty. We've talked around the issue a bunch, and let's get into the heart of the duty of loyalty. So what is the duty of loyalty? Well, again, we have agents. They're acting on behalf of their principal. We have directors. They're acting on behalf of the shareholders. The shareholders own the company. The directors merely run it, right? They're fiduciaries. They may feel sometimes like it's their company, but it is not their company. They are fiduciaries, and they have a duty of loyalty not to steal from the company. Now, unlike the duty of care, which we're going to really circumscribe because we want directors to take business risk, we do not want directors to steal corporate opportunities. We do not want our employees to be taking the opportunities from our company. So we have the doctrine of director conflict of interest transactions, and this has to do with when a director is on both sides of a transaction. And we're going to see a couple examples of that. These are not necessarily prohibited. They may be preferable, but they do create some fundamental issues. And we have some law to deal with it, right? We have the Delaware General Corporation Law, Section 144, and in MBCA Model Business Corporations Act jurisdictions, you'll find it under subchapter F. These are safe harbors that say, okay, even if there is a director on both sides, this is where you look to in the law to see whether or not this is a clean transaction or how to cleanse these transactions. And that cleansing process requires, really under both laws, very similar disinterested or independent, we'll talk about what that means in a moment, director approval, and shareholder ratification. So let me give you a brief example of a classic self-dealing, right, where we have a director on both sides of the transaction. And so we have CommuRent. CommuRent owns and leases a number of commercial buildings. Right? They're in the business of leasing buildings, and they lease one building to Big Box, Inc. Right? Think of Walmart. So you have your leaseor, your leasee. When Big Box faces financial difficulties, CommuRent agrees to waive bonus rents to help Big Box get on its feet. Now, it so happens that Big Box is closely held by Mr. and Mrs. Box. And that's why they named it Big Box. They like to name it after their company, and Ms. Box is also on the board of directors at CommuRent. So she stands on both sides, right? She is both the owner of the leasee and a director of the leaseor. And so as regards the leaseor, she now is in a conflict of interest transaction. Now, that's not necessarily bad, but there is a problem. There are good business reasons to work closely with people in these type of situations. Right? It might provide certain opportunities. But here, clearly, there's a risk that she's going to try to take some of that money from her company and give it to the one she's going to take money potentially from the company she's a director of and put it in her own pocket. Right? That's the risk we're trying to avoid. And unlike the business judgment rule, where we presume directors are acting in a well-intentioned way, when they're on both sides, they lose that presumption. So the duty of loyalty defeats the business rule presumption. And we have to look at fairness. Now, it used to be we looked at entire fairness, which was procedural fairness, plus substantive fairness. Modern courts require only one of the two. We'll talk about what those mean. But we don't want to necessarily prove that this transaction was fair. We might want to approve it in advance instead of going to court. So what can we do to avoid going to court and proving that we actually were acting fairly when Ms. Box told the rest of the board that they should waive rents to Big Box? Well, under DGCL 144, we have three ways of doing that. Disinterested approval by either the directors or the shareholders, provided the shareholders are informed. Procedural fairness or substantive fairness. So let's look at an unfair transaction. Totally unfair transaction in Remillard Brick. And what were the facts here? Stanley and Sturgis owned a majority of Remillard Dandini Co. And they sat on the board and controlled its wholly owned subsidiary, San Jose Tile Company. And they got into a transaction where the large parent company sold its bricks to a subsidiary, Remillard Dandini Sales Corporation, which was now entirely owned by Stanley and Sturgis. To make it simpler, basically what Stanley and Sturgis were doing is they were taking the sales from the parent company, which had other shareholders, and moving those sales and those profits to a company that they owned. In other words, the majority used their power for their own advantage, because what they tried to do to approve this merger was that they had a vote. Now, they are the majority shareholders, they are the majority directors. So what do you think happens when you have a vote? Well, they approved it. The other shareholders said no. They said, yes, we want to put the money in our pockets. The other shareholders said, no, don't steal from us. And what do we learn from this case? Well, this case was a little bit ugly, because it came out under an old California Section 820 rule that said that a interested director contract is not void or voidable if there is director approval, shareholder approval, or the deal is fair. And they neglected to think about the fact that what if the directors or shareholders are interested? So the court kind of twisted the language of the statute in a way that I really don't like, because they basically said that any means all. So don't look at this as an example of good law or good legislation, but what it leads us to is, thankfully, highlights the problem that if you simply had a vote, right, the people that are self-interested are going to vote for their favor. We can't cleanse this with a vote. We need to do something more. We need to focus on not the entire board, but the disinterested board. Not all the shareholders, but the disinterested shareholders. Right? California courts rightly saw what was wrong with Section 820. They mashed up, they misread, they pretended the words were different than they were. I don't like it when courts do that, but I understand why they did. Thankfully, Delaware came up with a better rule, and that's Section 144, which says an interested director transaction, a DCIT, in MBCA terms, will not automatically be void or voidable solely because of the director's interest if there has been informed disinterested board approval, or the shareholders made informed approval, or the transaction is fair. And this, in modern cases, means substantively or procedurally fair. We have one example of when one of these was found to be fair, in the case of Benihana of Tokyo versus Benihana Inc. So we have some colorful characters here. Rocky Aoki founded Benihana of Tokyo and its wholly owned subsidiary Benihana Inc., and they own restaurants worldwide. But they were kind of dated. Right? They had been around for a while, and they needed money for renovations. They weren't doing very well, and so they needed to look for money. They had trouble getting money until finally one of the directors of the company, a guy named John Abdo, put up his hand and said, I run a financial group. We could invest in Benihana. Now, this is a director who stands on both sides. He runs a financial group. He has an interest in the person who is going to finance this company. He's also the director of it. He clearly stands on both sides. Is that necessarily bad? No, it's not necessarily bad. It's not necessarily bad because they couldn't get the money from any other source. This was their best source of keeping their operations going. So can we fit under a DGCL safe harbor? Can we sue? And Rocky Aoki sued because two reasons. One, he said it was unfair, and two, this would dilute him away from his majority control. Right? Because when you issue shares, you're going to dilute the other shareholders, and so this one was ticked off because he didn't get to keep control of the company. So the questions here: was Benihana authorized to issue this stock to BFC, which was John Abdo's, a company that John Abdo, the director, had in? Well, we have to look at whether or not we're in the 144 safe harbor, which requires disclosure and approval. And the answer in this case is yes, right? We're going to find that the director's duty of loyalty was not violated because a director conflict of interest transaction is not voidable where it has been disclosed to and approved by disinterested directors or shareholders. And that's exactly what happened here. They had all the material information they needed. They knew that John Abdo was on both sides. They looked at the terms, and unlike Van Gorkom, they had actually gone through the process of finding out what this stuff was really worth. This was the best deal they can get after a lot of efforts. They spent a lot of time on the paper and process, and so this transaction was cleaned or cleansed. MBCA subchapter F, I'll mention briefly, is similar. It has a similar rule. It just is worded a bit differently. It defines a DCIT as a transaction where the director is a party or has knowledge and material financial interest known to him, where the director knows a related party who is a party or has a financial interest. And that gets us to the independence concept that really comes up in the Martha Stewart case. But it's effectively a similar rule where you can have a safe harbor where the conflict of interest transaction has been cleansed by a majority of qualified directors or a majority of disinterested directors. And what do they call qualified directors? That's defined as someone who does not have a conflicting interest in the transaction. So the independent directors, the ones that do not have a material relationship with the conflicted director. We could also go through a fairness review, right? But fairness can be found when there has been board approval or shareholder approval, and that's a type of procedural fairness. The court can also find that, or it can find that it was substantively fair, even if that didn't happen. But that's a very dangerous type of proceeding to get into, because then courts are making effectively hindsight business decisions. Hard to know how those are going to come out. Who's an independent director? That simply means not just that they have a financial interest, but also that they're not beholden to or dominated by another director. By the way, I'd like to go through all this and hold you a bit late, but we don't need to have class next week. So if you guys can stick around. If you have to go, you have to go. This is going to be recorded. But I know that we've only got 5 minutes left, so I'm going to run over, but I'm going to give you next week off. All right, so stick around if you can. If you can't, feel free to kind of shuffle out. This video will be available for you, but hopefully this review is going to be helpful. So independent directors, right? That's someone who is not dominated by or beholden to another director, which is more than having a financial interest. So we actually have to look for that, and we found that we did not have independent directors or independent members of a special litigation committee, similar concept, in the In re Oracle derivative litigation case. So what happened in this case? So Oracle is located in Redwood Shores, which is in Northern California near San Francisco. Also located in that area is Stanford University, located about 10 miles away. And Oracle being a major technology company, Stanford being a technology-focused university, they have a lot of ties, a lot of connections. So an Oracle shareholder sued Oracle, claiming that there was insider trading going on. And as we'll learn about when we talk about shareholder litigation procedure, we're talking about substantive shareholder rights. We'll talk about the procedural stuff later. We convene a special litigation committee that's going to hopefully be independent, non-biased, and determine whether or not this suit can go on. So Oracle did so. They convened a special litigation committee of entirely outside directors, so no employees of the company. They didn't take any fees. None of them had any business with Oracle. They weren't any contract parties. But 2 members of the committee were Stanford professors, and 3 others had strong ties to Stanford. And Oracle had strong ties to Stanford. The committee, after having a substantial amount of paper in process, many, many months of meetings, thousands of pages of written reports, said the suit should be dismissed. The directors should not be found liable. We're not going to go through the process of this suit. But surprisingly, here, the special litigation committee, similar to how you determine if directors were independent, was found to be not independent because Chancellor Strine said that there was a reasonable probability that the 2 Stanford directors were not capable of making a decision only with the corporation's best interests in mind. Well, why would that be? Because they weren't receiving any funds directly from engaging with Oracle. And in fact, one of them was a tenured, chaired professor at Stanford. But they said that those relationships were too close, and so that could disrupt independence. So that surprised people, because this seemed like a pretty good committee. A case that was maybe less surprising from a corporate standpoint, more surprising from a personal standpoint, was found in Beam XRL Martha Stewart Living Omni Media. And so Martha Stewart's a friendly lady. People really like her. Here she is hanging out with Snoop Dogg's baking brownies. I wonder what's in those brownies. She's hanging out with Snoop Dogg, baking brownies. She hangs out with a lot of people. She hangs out with her friends at weddings. She hangs out with her board of directors. She's friends with all of them. And there was a plaintiff who came along and sued Martha Stewart. I don't have her wearing her orange jumpsuit here, for breaching her duties of loyalty and care by selling stock of another company and then making misleading statements to the media. Bad move, Martha. She probably shouldn't have eaten the brownies. So plaintiff argued that the demand on the board was futile because of the social and business connection between Stewart and other directors. I guess they had read Oracle and they said, well, geez, I mean, if a Stanford director is not going to be independent, then Martha's best buddies are not independent either. I mean, there were allegations that Martha Stewart and the other directors moved in the same social circles, attended the same weddings, developed business relationships, even described each other as friends. Is demand excused? Surprisingly, no, demand was not excused, meaning the plaintiff did not allege enough specific facts to show that there was a lack of independence. Friendship and other business relationships are not enough. This is not to say, the court went on, that personal friendship is always irrelevant to the independence calculus, but for pre-suit demand purposes, friendship must be accompanied by substantially more in the nature of serious allegations that would lead to reasonable doubt about the director's independence. To create a reasonable doubt about director's independence, a plaintiff must plead facts that would support the inference that because of the nature of the relationship or additional circumstances, other than the interested director's stock ownership or voting power, the non-interested director would be more willing to risk his or her reputation than the reputation of the interested director. So that's where you get that beholden to. So they took it a little further and found that Martha's buddies were not really beholden to her, and they could have sued her, even though they were her friends. All right, in Lewis v. Vogelstein, we have a bit of a different conflict. This is a very common conflict. This had to do with the directors of Mattel Corporation. Okay? And Mattel Corporation, like many corporations, incentivizes its directors by offering them stock. It's a good thing, actually. You offer your directors stock because that way their interests are aligned with the shareholders. They want to maximize shareholder value because now they're shareholders too. And we don't have to take money out of the corporation's pockets, They need it for developing new Barbies. So they want to keep the money in the corporation. We're going to pay the directors with stock instead. It's generally a good idea. But, of course, when directors, who are the only ones who can issue stock, are issuing stock to themselves, you see how they stand on both sides of the transaction? Right? They're inherently conflicted. So what happened here? The shareholders challenged this compensation plan, even though it was approved at an annual meeting. So what happened here? Well, here, quite simply, it was ratified at the meeting. The shareholders had all the information. It wasn't complicated. This many shares of stock going to this director, this many going to this director. It's a public company. Everyone knows what the stock is worth. The shareholders approved it, and therefore they ratified it. And by ratifying it, it cleansed the transaction. So again, we see that disinterested shareholder approval can cleanse a director conflict of interest transaction. So the corporate opportunity doctrine, finally, the corporate opportunity doctrine is a subset of the duty of loyalty, and it addresses common director conflicts. This is when a director would take a corporate opportunity that belongs to the corporation or usurps it. We find the corporations have effectively an ownership right in some opportunities, and the directors as agents could potentially interfere and take that opportunity. The traditional case is found in Guth v. Loft, and in this case, it had to do with a director, Guth, who ran a company called Loft, which was a candy store. And this candy store wanted to sell soda. They had been selling Coca-Cola, but they were unable to get Coca-Cola at a volume discount. And this director, Guth, he went out and actually bought PepsiCo out of bankruptcy. Maybe got a fire sale price on it, but in any event, he bought the company and he ran it for himself, he kept it for himself, and he made a lot of money with this PepsiCo. In fact, you may have noticed that Loft is not around, and PepsiCo still is. So the Loft shareholders sued Guth for the lost Pepsi opportunity. Was this an opportunity that belonged effectively to Loft? Yes, it was. The shareholders won this case. This was an unlawful usurpation of a corporate opportunity when the corporate manager takes an opportunity for himself without presenting it to the corporation. And what we learned from this case is a corporate fiduciary cannot take a business opportunity for himself if it is one that the corporation can financially undertake, within the line of the corporation's business, advantageous to the corporation, and one in which the corporation has an interest or reasonable expectancy. This was a substantial expansion of the corporate opportunity doctrine. And we can see that in a more modern context in the case of Farber versus Servin Land Company, or SLC. Servin was an entity that was created to buy land and build a golf course. Golf courses obviously need quite a bit of land, and the majority shareholders and directors and principal officers were two gentlemen, Serini and Savin. So SLC owned a 180-acre golf course and a country club, and an individual named Farquhar, a third party, offered to sell the 160-acre tract of land directly adjoining it, right? So you have your golf course and your land offered for sale right next to it. The offer was presented to the shareholders. They didn't take it. They didn't take the opportunity at a meeting. And then Serini and Savin bought the adjoining land for themselves. Can they do that? Can they buy this land? Well, 4 years later, they sold that land, and they earned quite a healthy profit. They, in fact, sold the entire parcel, the 160-acre Servin and Serini parcel, and the 180-acre SLC parcel, for a total package for $8.3 million. And S&S took $3.3 million for themselves. $5 million went to SLC, the club. A minority shareholder in the corporation sued, alleging that Savin and Serini had taken this corporate opportunity to buy the lands. Did, in fact, Savin and Serini take this corporate opportunity? Right? Let's take a look at the analysis, right? Did a corporate opportunity exist? The court goes through. Did the stockholders decline this opportunity? Did the stockholders ratify it regardless? Or was there any harm even? We have to find harm in order for this to be invalidated. The court evaluated these issues and found that, yes, there was a usurpation of this corporate opportunity. The directors had breached their duty of loyalty to the corporation by purchasing this land and profiting from it. All right, let's take a look at those four elements as they're presented here. Was there a corporate opportunity? Court says the opportunity to acquire the Farquhar land was an advantageous one. It fit into a present significant corporate purpose as well as ongoing corporate policy, and the corporation had an active interest in it. Accordingly, the opportunity to buy the land constituted a corporate opportunity. Now, clearly, buying the land right next to your land within that scope of business. The next issue was whether the shareholders declined the opportunity. And the court finds that they did not decline the opportunity because the shareholders did not get appropriate information. They could only decline the opportunity if they did so when they were informed. Because the other stockholders relied on Seriani to initiate the investigation of the corporation's behalf, he may not now translate his inaction into a corporate rejection. He did not actually investigate what the land was worth at the time, and so the fact the shareholders did not know was his fault, and he was the one taking the opportunity. Did the shareholders ratify it later? They did learn about it. Did they ratify it? Well, it's only valid if their ratification was informed as well. And here, they were only informed again by Serini and Savin, who were telling the company bad information, so they were not properly informed. Finally, was there harm? Clearly there was harm here because the land was sold for quite a bit more than it was paid for. There was a large profit. That profit should have inured toward the corporation, not to its directors. And so we find from this case that we have 5 tests for corporate opportunity. The traditional approach here, as we see, has been to focus on the corporation and their core operations, and the rationale is that the opportunities should be held in trust by the trustees for that corporation unless it decides not to take them. So the interest or expectancy test asks whether or not the opportunity is within the interest or expectancy of the corporation. So this is much less enforceable than pure ownership rights. It's hard to necessarily find that there was an ownership right in this, but interest or expectancy is quite broad. So we see with this first test that a corporate opportunity is usually a very broad concept. So in the case of Guth v. Loft, here was an individual who understood that the company wanted to sell soda. He purchased a company that made soda. It makes perfect sense that a company that sells soda might at least be interested in buying a company that makes soda. Now, Guth did not meet this second test, but we do here the line of business test. Here we ask, is the offer in the same line of business as the corporation? Servin Land Company, in the business of owning land, clearly meets that standard. Now, in the case of Guth v. Loft, they currently sold soda? What if they didn't sell soda? Well, that puts us into the interest or expectancy. Maybe a candy shop would sell soda in 1939. We must also ask whether or not the corporation had the economic capacity to take on this transaction. It cannot be said to be a corporate opportunity if the corporation could not afford it. The fairness test examines whether the opportunity, if taken by the director, would have been fair to the corporation. And so that's sort of like the entire fairness review. It's a difficult test to make. Unsure how courts would come out, a lot of uncertainty there. And finally, the corporate rejection test asks, did the corporation receive the opportunity with full disclosure? Right? That was what was missing in Servant Land Company, and after full disclosure, decide not to take this opportunity. So, to summarize, the fiduciary duties that directors owe to shareholders are similar to and come out of agency law, but they're distinct in that they have been codified by Delaware General Corporate Law and other state statutes, and as a result, the agency law provides some background to the policies, but really we look to the DGCL for breach of fiduciary duties for a Delaware corporation. And so what are those duties? Directors owe three duties, as I see it. They owe duties of care when making commissions, when making decisions. They owe duties of oversight, that they cannot make omissions, that there are things they should do, and they can be liable if they don't do it, and they can be liable for breaches of loyalty, where they stand on both sides of a transaction or usurp a corporate opportunity. The business judgment rule has expanded to really protect a lot of duty of care breaches, so long as they're supported by paper and process. Van Gorkom, of course, pushing back on the validity of the business judgment rule where we failed to have paper and process, but that's not the usual case. And we can actually exculpate away that liability by enacting an exculpation clause pursuant to DGCL section 102(b)(7). We can also indemnify and insure directors. That will provide some additional protections against shareholder lawsuits. Why? Because we don't want to sue directors for making business decisions. If they're dumb, the shareholders should get them out of office or change corporations. The shareholders put them there in the first place, and so they can't later complain they're making stupid decisions, bad decisions. But they can complain when they're not making decisions, when they're not monitoring. And the duty of oversight requires the board to monitor because they're liable for legal risks and maybe other risks of which they know or should have known. And it's that should have known that requires them to implement monitoring systems. And finally, a duty of loyalty breach is going to be where there is a conflict of interest transaction or a usurpation of a corporate opportunity. And here we totally lose the presumption of the business judgment rule. We actually presume that the directors are doing something nefarious. And the shareholders have less of a burden once they've shown that there's a conflict. It becomes a burden of proof or persuasion of the directors to show that the transaction was procedurally or substantively fair. And that is the body of fiduciary duties under corporate law.